Now we're going to talk a little about law and justice. We have to start with a bit of criminal history. In earlier times, justice was carried out through revenge. You may have heard the expression, an eye for an eye, a tooth for a tooth. If someone had been subjected to a crime, retribution against the offender or their family was common. For example, a murderer would himself be killed in a form of blood revenge, and a thief would pay a fine. If the thief could not pay, he might have a hand or foot cut off. That was how justice was served back then. Gandhi said that an eye for an eye makes the whole world blind, because if we constantly avenge each other for past crimes, conflicts will never be resolved, and we cannot move forward. It is a very destructive system. Moving away from the principle of an eye for an eye requires a country to function as a state governed by the rule of law. You can open the first page of your notebook because this is very important. Several criteria must be met for a country to be considered a state governed by law. First and foremost, the country's laws must be written down so that it is clear what applies. Oral laws can be forgotten, which makes it extremely important that they are recorded in writing. Second, what is written in the laws must actually be applied. Even if there are well-formulated laws in the statute book, they are meaningless if they are not enforced. In a dictatorship, for example, not all laws may apply to everyone. Often, in dictatorships, some people are not subject to the law, which leads to certain groups being particularly vulnerable. For a country to count as a state governed by law, there must also be authorities, police, and courts. Only the police should have the right to make arrests, to prevent private individuals from taking the law into their own hands and abusing suspects. It is also important that only courts have the right to pass judgment. That ensures that everyone who is brought to trial is treated equally and receives a fair assessment based on evidence, which is crucial in a state governed by law. Many countries lack a functional court structure where autocratic individuals or informal groups take on legal decisions that really should be handled in a courtroom. Legal certainty means that identical crimes should lead to identical punishments. That is the basic idea. If someone believes that the court has judged wrongly, there must be an opportunity to appeal. Then all the evidence is once again presented before a new judge to ensure that the right sentence is imposed. If new evidence emerges indicating that an innocent person has been convicted, it is important that this person receives a proper review of the case. It is of utmost importance that everyone is treated equally under the law. If you and I commit the same crime, we should receive the same punishment. Another important aspect of legal certainty is minimizing the risk that innocent people are wrongly convicted. In addition, if I am accused of a crime, it is up to the prosecutor to prove that I am guilty. It is not my responsibility to prove my innocence. We will explore this in more detail later on. Now we're going to talk about the trial and what happens before, during, and after a trial. You can open page 2 in your notebook if you haven't already done so. As mentioned, the police have the primary responsibility for apprehending criminals, and you, as a private individual, do not have the right to apprehend someone and keep the person captive. That is strictly the police's job. This reflects the principles of a state governed by law, where we want to avoid situations like the one you see in the picture here from The Simpsons, where a group of angry citizens decide to hunt down the suspect themselves. It is precisely to avoid such scenarios that the role of the police is central. When a person has been apprehended, the prosecutor decides whether that person should be detained. A person is detained if there is reasonable suspicion, meaning it's likely that the person committed the crime they are accused of. A suspect can be detained for up to 4 days. During this time, the police and the prosecutor have the opportunity to gather evidence and all other information needed to prepare a trial. However, the maximum time the person can be detained is 4 days. The court decides whether a person should be remanded in custody, and remand is applied only if the crime is particularly serious, such as murder. Another reason for remand can be the risk that the suspect will obstruct the preliminary investigation. If there is a risk that the suspect could, for example, wipe away fingerprints from a crime scene, which would destroy evidence, that is reason enough to keep the person in custody. In this way, the police can work undisturbed to collect and secure evidence before the trial. So, to summarize, apprehension is carried out by the police, and a person can be held apprehended for a maximum of 12 hours. The prosecutor plays a central role in the next step. He or she decides whether a person should be detained, which means the person can be kept in custody for up to 4 days. If the crime is more serious, such as murder, the prosecutor can request remand. The decision on remand is made by the court, and the suspect can then be held in custody, usually for 2 weeks, but the period can be extended depending on the seriousness of the crime. In a courtroom, especially in the district court, which we are focusing on, the bench consists of 4 people, 1 judge and 3 lay judges. In addition, there is a clerk who records what is said during the trial. On one side of the courtroom sits the defendant, the person who is accused of the crime. On the other side sits the prosecutor, a legally trained person whose task is to prove that the defendant is guilty and to represent the victim. The opposing party, the defense lawyer, is also a lawyer whose primary goal is to defend the accused. This is important because many people do not know how a trial works, how to respond to evidence, and so on. Having a defense lawyer not only helps the accused navigate the legal process, but also ensures that the verdict is correct. This is a central part of legal certainty, where the defense lawyer ensures that the accused is not wrongly convicted of a crime they did not commit. You can now open the 3rd page in your notebook, because now we are going to talk about the trial. The trial begins with the judge checking that everyone is present in the courtroom. Then, the prosecutor presents the crime and explains why they believe the accused is guilty. An important moment is when the judge asks the accused whether they admit or deny the crime. Regardless of the answer, the trial continues with the presentation of the facts, where the prosecutor describes how they believe the crime was committed. The prosecutor also sets out the evidence, which may include fingerprints, DNA, or other traces found at the crime scene. The defense lawyer's task is to present their version of events, which is an important part of the trial. It can be likened to a duel where both the prosecutor and the defense present their views and arguments. The prosecutor puts forward evidence and arguments that the accused is guilty, while the defense lawyer presents evidence and arguments that support the accused's innocence. A key aspect is establishing an alibi for the accused, especially in serious cases such as murder. If it is claimed that a crime was committed at a specific time and place, it is important that the defense lawyer can show where the accused actually was at that time if they were not at the crime scene. If you are suspected of a crime, but were at home watching TV on Thursday, it is important to prove your presence somewhere other than where the crime was committed. This can be supported by, for example, witness testimony or other evidence. During the trial, witnesses are called to give their accounts under oath. They promise not to lie, because giving false testimony under oath can itself be considered a crime. Therefore, it is extremely important not to lie to the court. The defendant is not required to testify, and there is no obligation for the defendant to speak. The trial ends with closing speeches where the prosecutor sums up the case and proposes an appropriate sanction. Finally, the verdict is announced, where the judge informs the accused whether they are convicted or acquitted. There are different types of legal cases. Criminal cases are perhaps what most people think of when they hear the word trial. In a criminal case, a crime has been committed, and the trial aims to investigate and adjudicate the matter. But there are also civil cases where no crime has been committed. Civil cases instead concern disputes between parties, for example, in matters of inheritance, divorce, or child custody. In these cases, the court decides who is in the right in the dispute between the parties involved. We can return to the discussion of appeals that we talked about when we discussed legal certainty. You can take out page 4 in your notebook. All cases that are brought before the courts are first heard in the district court, which we discussed earlier. If someone believes that the wrong sentence has been imposed or that the trial was not properly conducted, they can ask the Court of Appeal to review the case. The Court of Appeal handles cases that have been appealed, which means that the trial is conducted again to ensure that the verdict was correct. It is a bit like when a teacher lets another teacher review a test to ensure that the grading is fair. You then check twice to guarantee accuracy. If there is still doubt after the Court of Appeal's decision, the case can be appealed further to the Supreme Court. The Supreme Court only takes cases that can serve as guidance for future similar cases or precedents. They can also take cases if new evidence has emerged or if an obvious mistake was made by the Court of Appeal. However, it is not common for the Supreme Court to choose to take up a case, and this happens only under special circumstances. Why are criminals punished then? Well, criminals are punished primarily to deter people from committing crimes. The idea is that if you are aware that there is a high risk of punishment if you commit a crime, you will choose not to commit the crime in the first place. Punishment also serves to protect other citizens from the criminal, especially if the person is dangerous and likely to commit more crimes that could harm innocent people. Another important aspect, which is often forgotten, is rehabilitation. The aim of punishment is not only to impose a penalty, but also to provide the criminal with opportunities for care and to learn to live a life without crime. Our legal system is designed so that the punishment should also function preventively. The person who has been punished should be motivated not to commit more crimes in the future. Now let's talk about penalties. The most common sanction for minor offenses is a fine. It is a common punishment for traffic violations such as speeding. The size of the fine is adapted to the seriousness of the offense and the person's income. This means that if you have a high income, your fine will be higher, and if you have a lower income, it will be lower. The aim is for the financial impact of the fine to feel the same for everyone, regardless of income level. This is called the day fine. For example, a person with a high income may feel that a certain amount is marginal, while the same amount can be a significant financial burden for someone with a lower income. Therefore, the fine is adjusted so that it is proportional to the offender's financial circumstances. One sanction used is a conditional sentence, where the convicted person avoids prison on the condition that no further crimes are committed. It works like a warning. If the person commits a crime during the probation period, they can be sentenced to prison. Another sanction is electronic monitoring, which is applied to prison sentences shorter than 3 months. The convicted person wears an electronic device around the ankle, making it possible to serve the sentence at home. The person is allowed to move freely to and from work and other necessary errands. If the person is in prohibited places, the device sends a signal to the police. These alternatives allow the individual to continue daily life, which can reduce the risk of continued criminality by maintaining jobs and social ties. It is also cost-effective compared with prison, which benefits the national economy. For persons who are mentally ill at the time of the offense, compulsory psychiatric care is imposed as a sanction. Instead of prison, adequate treatment is offered, based on the idea that the person did not have the capacity to act differently at the time of the crime. For more serious crimes, prison is a common sanction. The sentence length can vary from 2 weeks up to life. Although a life sentence can theoretically mean that the person remains locked up for the rest of their life, this is usually not the case in practice. In Sweden, life imprisonment usually means that the prisoner serves about 25 years before the possibility of release is considered. Release is based on assessments of rehabilitation and the prisoner's readiness to return to a reasonably normal life. In Sweden, there are prisons with different security classes. The image many people get in their heads when they think of prisons is often the closed institutions, which are surrounded by high walls and guard towers, and where security is strict. These institutions are intended for inmates who are not allowed to leave the facility. There are no opportunities for them just to walk out and leave the place. Those placed here are usually convicted of serious crimes. Examples of such high-security institutions are Hall and Kumla, where there are special security units for prisoners considered likely to escape or who may risk being freed by accomplices. These prisons represent the type of facility many people think of when they hear the word prison. Security Class 3 represents a milder form of prison in Sweden. These institutions lack fences, walls, and other escape barriers, creating a more open environment. The idea is that inmates either spend the end of their prison term here, or that those convicted of milder crimes are placed in this class. The goal of these prisons is to prepare inmates for reintegration into society. There are often educational programs and other types of training aimed at helping inmates live a normal life after release, including preparing them to get a job. It is not uncommon for inmates in Security Class 3 to be granted furloughs if they have behaved well. During these furloughs, they can spend a few hours outside prison, for example, to have dinner or go shopping, and then return to the institution. These furloughs are another step in the process of reintegrating inmates into society, which is the overall goal of the sanction. In Sweden, you become criminally responsible at the age of 15, which means that you can theoretically be sentenced to prison if the crime is serious. However, the approach to young offenders is different from that for adults. For young criminals, the focus is more often on help than on punishment. This is because young people who end up in prison risk developing poorer social networks and being negatively influenced by other inmates. Instead of prison sentences, other methods are explored that can support the youth's rehabilitation and reintegration into society. When it comes to the legal process for minors, when a minor is questioned, it is mandatory that a guardian or other responsible adult is present. This is to protect the young person during a process that can be particularly stressful and taxing. The aim is to handle young offenders in a way that maximizes their chances of living a law-abiding life in the future, with greater focus on support and rehabilitation than on punishment. Now, as we approach the end of this video, you can look at the list on the left. It contains important topics you need to understand. You should have knowledge of the rule of law and legal certainty. It is important to know what these terms mean and why they are important in a society. Understanding the different types of punishments and the reasons behind them is also crucial. You must understand how a trial is conducted and what happens before and after the trial. Finally, it is important to understand why people commit crimes and what happens to young people who commit crimes. If you feel you lack knowledge about any topic, you can watch the video again. In addition, you need to be familiar with the terms. The terms are translated from Swedish to your language in the video description. Check the description to make sure you understand all the terms. Thank you for watching, and if you want to see the next video, you can click up here.